Hello friends, welcome to Analytics IS Academy and our YouTube channel Let's Crack IS, Analytics IS, where we have been doing a series of lecture targeting your UPSC CSC Prelims 2020, in which we have been covering number of important aspects related with your prelims examination on number of subjects like Indian geography, like Indian polity, Indian economy. We are trying to cover almost 500 to 700 important concepts from where UPSC has been asking repeatedly question in previous year prelims examination. So friends, the only motive, only aim of our this program, this crash course, which is absolutely free for all aspirant, that is to help you to develop better conceptual understanding with regard to these important aspects related to your general studies and CSAT syllabus, on which your prelims examination is going to be held in month of October. In this particular session on polity section, I have been covering a number of important areas which are related with Indian polity and constitution section, where I have already covered certain important aspect of your syllabus, and right now I have been covering your one important aspect, that is Supreme Court of India. And in last lecture on Supreme Court, I tried to discuss with you people process of appointment of judges of Supreme Court, and in that we tried to understand that how this process of appointment of judges of Supreme Court has evolved from 1950 till 2015, where till 1919 there was important role of executive in appointment of judges of highest judiciary in India, and how in second judge's case 1993 we discussed that a collegium system was evolved by judiciary itself, where judiciary came up with a collegium system where judges they themselves will appoint other judges. There was one attempt by executive in 2014 through 99th Amendment Act, where they proposed one body known as National Judicial Appointment Commission. But again in 2015 that 99th Amendment Act was struck down by judiciary as unconstitutional and illegal, and again we came back to basic, where a judges collegium consisting of Chief Justice of India and 4 other senior most judges of Supreme Court, they are appointing other judges of Supreme Court. So that aspect and removal of judges of Supreme Court that we discussed in the last class, in this particular session, in this particular lecture, I am going to cover one important aspect related with the Supreme Court of India, that is jurisdiction of what? Supreme Court. And in that we will try to understand the powers and jurisdiction of Supreme Court, and under jurisdiction of Supreme Court we will discuss writ jurisdiction, we will try to understand court of record, we will try to understand original jurisdiction, appellate jurisdiction, idea of advisory jurisdiction, judicial review, all these aspects that we are going to cover in this particular session of 1 hour, where I am going to cover these important aspects from where बार बार यूपीएससी ने क्वेश्चन यहाँ से पूछे हुए हैं. So under these heads I am going to cover different types of jurisdiction of Supreme Court, what exactly is writ jurisdiction, what exactly is court of record, what exactly is original jurisdiction, appellate jurisdiction, advisory jurisdiction, judicial review, and other powers. So out of these verticals, these blocks, you will find certain things I have already covered with you people while discussing chapter of fundamental right, that is part 3 of Indian Constitution, जहाँ पे मैंने आपके साथ already writ jurisdiction, already आपके साथ judicial review discuss किया हुआ है. Again I will refer these things in this particular lecture, but in detail I have already discussed these aspects while discussing chapter of fundamental right. तो आप लोगों में से जिनका भी मिस हो गया है, those who miss that particular aspect, through our playlist they can go to our fundamental rights section, where we have already covered writ jurisdiction and power of judicial review of Supreme Court. Here again I will give you reference. So as far as articles are concerned, कि constitution के कौन से articles हैं जो इन power से इन jurisdiction से deal करते हैं, तो on your screen you may see that article 13 and article 32 that we have already discussed while discussing chapter of fundamental right. They deal with power of judicial review and power of writ jurisdiction. Then article 129 से article 136 तक आप पाएंगे कि these are the articles which are largely in sequential order, and these articles deal with various other aspects like court of record, original jurisdiction, constitutional criminal and matters पे सुप्रीम कोर्ट की जो पावर है that is to appellate jurisdiction. Then special leave petition is mentioned under article 136. Article 143 talks about advisory jurisdiction. So these are the articles that are dealing with different aspects or different powers of what Supreme Court of India. One by one we will discuss all these things. So सबसे पहले जो important thing I am going to discuss with you people, that is writ jurisdiction of Supreme Court. And while discussing writ jurisdiction here, I am saying that already I have covered this aspect in much detail while discussing fundamental right. And fundamental right में I have discussed with you people one important fundamental right, that is article 32, where we discuss right to constitutional remedies, जहाँ पे हमने ऐसा पाया कि सुप्रीम कोर्ट ऑफ इंडिया is the protector and promoter of fundamental rights of an individual. So fundamental rights जिनके बारे में हम ऐसा डिस्कस कर रहे थे कि these rights are hierarchically most important right which are very essential for your fullest physical, intellectual and spiritual existence. अगर उन fundamental rights का violation होता है then a petitioner may directly approach where Supreme Court, वो हाई कोर्ट भी जा सकता है, but high court may refer a person to Supreme Court also. And because of that I am saying that while being final protector and promoter of fundamental right of an individual or a citizen of India, Supreme Court has power to issue 5 different kinds of writs. So writ का अगर dictionary meaning आप देखें तो writ is nothing. Writ means a kind of order, writ means a kind of direction, writ means a kind of stick that is there in the hand of Supreme Court. So ये 5 तरह के order, ये 5 तरह की direction सुप्रीम कोर्ट दे सकते हैं लेजिस्लेचर को या एग्जीक्यूटिव को, अगर उनके किसी एक्ट से पर्सन के फंडामेंटल राइट्स का वॉलेशन हुआ है. और ये 5 राइट्स डिटेल में मैं आपके साथ ऑलरेडी डिस्कस कर चुका था वाइल डिस्कसिंग आर्टिकल 32. तो यहाँ पे आई एम जस्ट गिविंग यू ए रेफरेंस कि सच 5 काइंड ऑफ रिट्स कैन बी इशूड बाय सुप्रीम कोर्ट वाइल protecting your fundamental rights if these rights are found to be violated. And further I am saying कि ये जो पावर है सुप्रीम कोर्ट की रिट्स इशू करने की, दैट इज़ नॉट एक्सक्लूसिव पावर, इट इज़ अ पावर along with the high court. So under article 226 we have already discussed कि high courts can also issue writs, supreme court can also issue writs. So power of supreme court to issue writ is mentioned under article 32 and power of high court to issue writs is mentioned under article 226. But yes, here you will find one important difference. Supreme Court of India, अगर आपके किसी fundamental rights का violation हुआ है and if you are approaching Supreme Court for enforcement of that fundamental right which is found to be violated, Supreme Court writ issue करने से मना नहीं कर सकते. They cannot refuse to issue writs in case of violation of fundamental right of an individual if he has approached Supreme Court for enforcement of these rights, for re-establishment of these rights. So there is a constitutional duty on the part of Supreme Court that they have to bring back your fundamental right if these rights are found to be violated. यहाँ पे मैं ये कहना चाह रहा हूँ कि under article 226, Article 226 is not a fundamental right. So High Court they may even refuse to issue writs if a person approach High Court for enforcement of fundamental right. But Constitution makers ने Supreme Court of India को फाइनल प्रोटेक्टर ऑफ फंडामेंटल राइट की तरह से इस्टेब्लिश किया है, जहाँ पर सुप्रीम कोर्ट की ये जो पावर है टू इशू रिट्स अंडर आर्टिकल 32, दैट इटसेल्फ हैज बीन मेड अ फंडामेंटल राइट. So this difference you have to understand. That is a writ issuing power of Supreme Court and writ issuing power of High Court. High Court is enjoying this power under Article 226. So there is no such constitutional obligation. ऐसी कोई constitutional obligation नहीं है High Court पे कि they have to issue writs if a person has approached claiming that his fundamental rights are violated. But in case of Supreme Court, मैं बोल रहा हूँ कि there is a constitutional duty on the part of Supreme Court. Supreme Court refuse नहीं कर सकता क्योंकि Article 32 itself has been made what? A fundamental right. So that is one difference between writ issuing power of Supreme Court and writ issuing power of High Court, जो आगे जाके भी हम डिस्कस करेंगे. दूसरा इंपॉर्टेंट डिफरेंस दोनों में मैं ये बोल रहा हूँ कि सुप्रीम कोर्ट ऑफ इंडिया कैन इशू रिट्स ओनली फॉर enforcement of fundamental right, not for any other right. But high courts can issue writs not for only enforcement of fundamental right, but also for the enforcement of other legal right. कहने का मतलब ये है कि सुप्रीम कोर्ट से ज़्यादा वाइडर रिट जुरिडिक्शन पावर है हाई कोर्ट्स की, क्योंकि हाई कोर्ट्स फंडामेंटल राइट एज वेल एज अदर लीगल राइट्स के मैटर में भी रिट इशू कर सकते हैं. But Supreme Court, they can issue writs only for fundamental right. So High Court, fundamental right plus other legal right. Supreme Court only in case of what? Fundamental right. So whose power is more wider? Power of High Court in case of writ jurisdiction is more wider than that of what? Supreme Court. ये चीज़ें मैंने पहले भी आपके साथ डिस्कस की हैं while discussing Article 32. Again, I am discussing here while discussing writ jurisdiction power of Supreme Court under this head of powers and jurisdiction of Supreme Court, just to revise it, जिससे चीज़ें आपको रिवाइज हो जाएं. हैबियस कॉर्पस क्या है, मैंडेमस क्या है, प्रोहिबिशन क्या है, ये सारी चीज़ें एक लेक्चर में मैंने आपको डिटेल में एक्सप्लेन की है. सो आप में से जिन्होंने भी उसे मिस किया है, दे कैन गो थ्रू आवर प्लेलिस्ट, दैट लेक्चर इज देयर एंड दे कैन हैव अ फेयर आइडिया कि व्हाट ऑल आर दीज 5 टाइप्स ऑफ writs. After discussing writ jurisdiction, the next important thing I am going to discuss with you people, that is court of record, which is mentioned under Article 129. So court of record का मतलब क्या है? What all are the powers with which Supreme Court of India is equipped with? When we refer Supreme Court of India as a court of record, that is one important aspect that I am going to explain you people. So Article 129 says that Supreme Court shall be referred as court of record. और जब आप बोलते हैं कि Supreme Court shall be referred as court of record, इसके दो मायने हैं. There are two meanings of this thing. पहला मतलब ये है कि judgments, directions and orders of Supreme Court of India will be used as a precedence, will be used as a reference by all other courts of India working under this constitution. So lawyers, they will use these case judgments as a precedence, as an example for future cases. That is the first meaning of what? Referring Supreme Court of India as court of record. And second meaning of court of record is that Supreme Court has power to punish individuals or an organization for contempt of court. So in order to protect its integrity, in order to protect its sanctity, Supreme Court has been given power to punish individuals or organization for contempt of Supreme Court. These two things are included, these two powers are mentioned under Article 29 when we refer Supreme Court of India as a court of record. So when we refer any court as a court of record, they have been equipped with these two major power. पहली पावर मैं ये बोल रहा हूँ कि उनके जजमेंट, डायरेक्शंस, ऑर्डर्स, they will be used as a reference, they will be used as an example, they will be used as a precedence in all other courts of India. And second thing I am saying that they have power to punish individuals for contempt of court in order to protect their dignity, in order to protect their integrity, in order to protect their sanctity, because Supreme Court को हम बोल रहे हैं कि they are the final interpreter of what? Constitution. So a body which we are referring as final interpreter of constitution, that body should be given such powers. So their decisions, their orders, their judgment will be used as a legal reference. आगे जाके हम आर्टिकल 141 भी आपके साथ डिस्कस करेंगे और आर्टिकल 141 इस बात को और ही क्लियरली बताते हैं कि एनी जजमेंट, एनी डायरेक्शन, एनी ऑर्डर गिवन बाय सुप्रीम कोर्ट ऑन सम स्पेसिफिक मैटर्स, they will act as a law for all other high courts and subordinate courts functioning in Indian constitution. So that is the importance of Supreme Court when I say कि their judgment, their orders, their directions can be used as a precedence, can be used as an example, can be used as a reference in all other courts of India. Second thing I was saying that they have power to punish individual or organization for contempt of court. So that we need to understand that what exactly is contempt of court, and this contempt of court is covered under one such act passed by Indian Parliament, that is Contempt of Court Act 1971. जो इस कंटेम्प्ट के एक्ट को दो कैटेगरीज में डिवाइड करते हैं. कुछ एक्ट्स को दे आर रेफरिंग एज सिविल कंटेम्प्ट एंड सर्टेन एक्ट्स दे आर रेफरिंग एज criminal contempt. So what exactly is civil contempt? What exactly is criminal contempt? One by one we are going to discuss. When we say civil contempt means disobeying judgment, orders and directions of court or any undertaking that you have given in front of court. So कोर्ट के किसी ऑर्डर को, कोर्ट के किसी जजमेंट को, कोर्ट के किसी डायरेक्शन को अगर आप विलिंगली डिसोबे कर रहे हैं, डेलिबरेट तरीके से डिसोबे कर रहे हैं, इंटेंशनली आप डिसोबे कर रहे हैं, देन दैट एक्ट में कम अंडर सिविल कंटेम्प्ट. हियर दिस थिंग यू हैव टू कीप इन योर माइंड दैट आई एम सेइंग इट शुड बी विलफुल, इट शुड बी डेलिबरेट, इट शुड बी इंटेंशनल. सो कोर्ट ने अगर कोई आपको डायरेक्शन दिया है किसी मैटर में दैट यू नीड टू पे 25,000 रुपीज़ टू अदर पार्टी, विक्टिम जिसने आपके अगेंस्ट में केस किया है, और आपके पास पेइंग कैपेसिटी है, उसके बाद भी आप कोर्ट के डायरेक्शन को, ऑर्डर को डिसओबे कर रहे हैं, देन इट कैन बी फिट केस फॉर कंटेम्प्ट. बट यस, because of lockdown, if you are saying ki since last 4-5 months you have not been able to earn any single penny and for the timing you will not be able to pay, then that may not come under contempt. That judiciary may consider, considering our judiciary as very progressive and rational judiciary. So here what I am referring that your disobeying, your refusal or your ignorance should be deliberate, it should be intentional, it should be willful. आपके पास पेइंग कैपेसिटी है, then also you are disobeying court order and direction, then it is a fit case for civil contempt. And now what exactly is criminal contempt? So when we talk about criminal contempt, this is also covered under Contempt of Court Act 1971, and Contempt of Court Act 1971 says that through writing, through publication of any material, through your arguments, through debate, discussions, if you are trying to scandalize, if you are taking any attempt to scandalize, or you are trying to lower the image, dignity of judges or judiciary as such, then this particular act will come under criminal contempt. If you have some strong prejudices against judicial functioning, you want to obstruct judicial proceedings, or you are trying to obstruct in execution of judicial order or judicial direction, then all these act will come under contempt known as criminal contempt. So there is a difference between civil contempt and criminal contempt. So judiciary may be liberal in cases of civil contempt, but judiciary is very harsh on matters which come under criminal contempt, where you are trying to scandalize, you are trying to lower the dignity, image of judges, you are trying to disturb in implementation of judicial order or direction. All these acts will come under criminal contempt, and only Supreme Court and High Court, they have this contempt jurisdiction. Subordinate courts, they don't have contempt jurisdiction. This thing you people have to keep in your mind from your examination point of view, कि केवल सुप्रीम कोर्ट और हाई कोर्ट को ही ये कंटेम्प्ट jurisdiction पावर दी गई है. This power has not been given to subordinate courts. So Supreme Court can punish individuals not only for its own contempt, but also for the contempt of High Court, also for the contempt of tribunals and subordinate court. That is a power of Supreme Court. But High Courts, they can punish only for contempt of their own contempt and for the subordinate court, not for tribunal. That is one important thing that you have to keep in mind. फिर से मैं repeat कर रहा हूँ, ये एक important fact है, one important issue that you have to keep in your mind कि Supreme Court आपको punish कर सकते हैं not just for their own contempt, but High Court और बाकी ट्राइब्यूनल के कंटेम्प्ट के लिए भी आपको पनिश किया जा सकता है. बट हाई कोर्ट दे कैन पनिश यू for their own contempt and for the contempt of subordinate court, not for contempt of tribunal. And mostly punishment will be in form of either some financial fine or imprisonment, or it may be both. That's some fine and some imprisonment, which may range from 2000 rupees to 6 months of imprisonment. Such kind of punishment can be given under contempt jurisdiction of Supreme Court and High Court. This contempt jurisdiction takes its origin from modern day England, but time to time debate has been raised that this contempt jurisdiction may come in conflict with our freedom of speech and expression. क्योंकि जब मैं आपके साथ आर्टिकल 19(1) सब क्लॉज ए डिस्कस कर रहा था, at that time I discussed with you people कि how your right to freedom of speech and expression can be restricted in the name of contempt jurisdiction or defamation of judges. So in a democracy like India, which is a functioning democracy, many times media houses, publication houses, they have raised objection on contempt jurisdiction, saying that to some extent it restricts right of media to express its own viewpoint against certain judgment, against some judicial proceedings, because it may come under civil or it may come under criminal contempt. Next important jurisdiction that I am going to discuss with you people, that is original jurisdiction. And original jurisdiction is mentioned under Article 131 of Indian Constitution. So friends, here one important difference you need to understand between original jurisdiction and exclusive jurisdiction. Even though this word exclusive jurisdiction is not mentioned in our Indian Constitution, but for your better understanding, I just want to make it clear that there can be a difference between original jurisdiction and exclusive jurisdiction. ओरिजिनल जुरिडिक्शन का मतलब ये है कि वो उस तरह के केसेस, दोज केसेस that may directly go to Supreme Court. So just now I discussed with you people that in case of violation of your fundamental right, even though you may approach High Court also, but considering the important sanctioned nature of this fundamental right, how important fundamental rights are, a petitioner may directly approach where? Supreme Court also. So it may also come under original jurisdiction that you are directly approaching. So those cases which will directly land to where? Supreme Court, and cases which can be only heard by what? Supreme Court, which may be referred as exclusive jurisdiction of what? Supreme Court. But since Constitution nowhere talks about term exclusive, and because of that such cases are also covered under what? Original jurisdiction of Supreme Court. Now one by one I will try to explain you that what all are those matters which will come under original jurisdiction of Supreme Court. So under original jurisdiction of Supreme Court, Supreme Court only has this right to transfer cases from one High Court to other High Court. So if Supreme Court of India is convinced that this matter is of political nature and impartial neutral justice cannot be delivered because of the political nature, political influence of the person who is in question, so they may transfer any case from one High Court to another High Court. Then Supreme Court can transfer case from any subordinate courts to some other state's High Court that also come under original jurisdiction of Supreme Court. Then if a case is pending before any High Court, and if Supreme Court considers that this case involves important interpretation of law, important interpretation of Constitution, then also Supreme Court may withdraw that case from High Court and can take it before itself. That is also one original jurisdiction of Supreme Court. So as a federal court also, when there are certain issues between center and state, or center and group of state on the other side among the states, such matters are referred as federal matters, and these federal matters can only be heard and disposed of by Supreme Court of India. That was I was referring as exclusive jurisdiction. But since this term exclusive is nowhere mentioned in Indian Constitution, and because of that this also comes under original jurisdiction of Supreme Court. So friends, now you must be having some clear idea that what I am referring as original jurisdiction and what I am referring as exclusive jurisdiction, but since this term exclusive is not mentioned in Indian Constitution, so those matters which I am referring as exclusive matters, they are also covered under original jurisdiction of Supreme Court. But yes, there are certain exceptions. And what are these exceptions? That a private individual, he cannot drag state into Supreme Court. Please correct it. Speed is not, there is a state. यहाँ पे spelling mistake है. So state into Supreme Court under original or exclusive jurisdiction of Supreme Court. We can challenge state in court of law, but through ordinary judicial proceedings, not through under original jurisdiction. So original jurisdiction under Article 131, mind it is not available to private citizens, private individuals. They cannot drag a state into Supreme Court under original or exclusive jurisdiction. If they have some issues, they may approach through ordinary judicial process, that is subordinate court, high court, then finally Supreme Court. Then questions which are of political nature, they will not be heard under original jurisdiction of Supreme Court. So those matters which are of political nature, they cannot be made a matter under Article 131 and original jurisdiction. These are one exceptions. Second set of exception I am saying कि आगे जाके जब आप साथ इंटर स्टेट वाटर डिस्प्यूट ट्राइब्यूनल की बात करेंगे, so if there is some water dispute between or among state, so Article 262 talks about some interstate water dispute tribunal, and such matters, even though they are of kind of dispute between two states on one side, one state on the other side, or one state on one side, second state on the other side, but such matters will not come under original jurisdiction of what? Supreme Court. We may take it to Supreme Court under some other route like special leave petition, but we cannot take it under this route, that is original jurisdiction. ये आपको समझने की कोशिश करनी पड़ेगी. What I am trying to say, I am saying कि आर्टिकल 262 इंटर स्टेट रिवर वाटर डिस्प्यूट के मैटर्स को एग्जेम्प्ट करता है अंडर ओरिजिनल जुरिडिक्शन. इसको आप दूसरे तरीके से सुप्रीम कोर्ट के पास ले आ सकते हैं, बट नॉट अंडर आर्टिकल 131 दैट डील्स विद ओरिजिनल जुरिडिक्शन ऑफ सुप्रीम कोर्ट. देन नाउ वी आर गोइंग टू डिस्कस एपेलेट जुरिडिक्शन. और एपेलेट से मेरा मतलब ये है कि दोज मैटर्स विच विल रीच टू सुप्रीम कोर्ट थ्रू एन अपील. सो जो एक ट्रेडिशनल अंडरस्टैंडिंग हमारे माइंड में है, दैट ट्रेडिशनल अंडरस्टैंडिंग सेज दैट इंडियन जुडिशियल system is hierarchically arranged, where at the bottom subordinate courts are there, and at the top, at the apex, Supreme Court of India is there. And petitioner first approaches subordinate court. If he is not satisfied with the judgment of subordinate court, then he reaches high court, and high court से अगर आप satisfied नहीं है, then you approach Supreme Court of India. That is a general traditional understanding that most of us we have, that this process we have to follow, this traditional process we have to follow, that kind of the understanding we have. But friends, mind it, this myth you should not carry. बहुत सारे ऐसे मैटर्स हैं जो हाई कोर्ट से सुप्रीम कोर्ट से जा ही नहीं पाते unless until they fulfill certain criterias. So if only then fulfilling certain criterias, then only such cases will reach Supreme Court. Otherwise such cases will not be able to reach Supreme Court. So Supreme Court's appellate jurisdiction extends over all kind of cases like constitutional matters, civil matters, criminal matters. In all types of matters, jurisdiction or appellate jurisdiction of Supreme Court extends. There is another kind of the jurisdiction, that is special leave petition. I will discuss under Article 136, even though that is not coming under appellate jurisdiction, but यहाँ पे भी petitioner अपनी अपील लगा सकते हैं, जैसे special leave petition बोल रहे हैं. One by one I will try to discuss, but what I am saying है कि हमें ये presume नहीं करना चाहिए कि हर केस जो हाई कोर्ट ने डिसाइड किया है उसके लिए आप अपील कर सकते हैं कहाँ पे? सुप्रीम कोर्ट. यू कैन अप्रोच सुप्रीम कोर्ट ओनली व्हेन दैट केस फुलफिल सर्टेन वेल डिफाइंड क्राइटेरिया. सो इन केस ऑफ द कॉन्स्टिट्यूशनल मैटर्स सच appellate jurisdiction is mentioned under Article 132, where if High Court certifies कि ये जो केस है that involves important interpretation of law, or it requires interpretation of constitution, a significant interpretation of constitution, then since Supreme Court of India is the final interpreter of constitutional provision, such matters will reach to Supreme Court as an appeal. क्योंकि ऐसा सर्टिफाई किया है किसने, हाई कोर्ट ने. सो दिस क्राइटेरिया इज गेटिंग फुलफिल्ड, देन पिटिशनर में अप्रोच सुप्रीम कोर्ट विथ एन appellate petition, and here Supreme Court's appellate jurisdiction will exercise on such matters. Then civil matters, if High Court certifies that this case involves substantial question of law and that question need to be finally interpreted, finally decided by Supreme Court of India, then petitioner may approach Supreme Court and Supreme Court will admit such an appeal because such certificate has been given by High Court. High Court is certifying that this particular civil matters involves important interpretation of law and that interpretation should be given by our Honorable Supreme Court. Then this matter will reach Supreme Court through an appeal. Then in criminal matters, here you need to be very focused. In criminal matter, Article 134 is saying that if High Court has certified that even after acquittal from subordinate court, High Court has reversed the decision and it imposed the sentence of death or a life imprisonment or an imprisonment beyond 10 years, then there is a since complete reversal of justice. सबॉर्डिनेट कोर्ट ने एक्विट कर दिया था और हाई कोर्ट ने ऐसे मैटर पे न केवल कन्विक्ट किया है बट आपको एक सिग्निफिकेंट पनिशमेंट दिया है, देन this matter is qualified for an appeal before Supreme Court. And if High Court has withdrawn any case from subordinate court and it has convicted individual and sentenced him to death or a life imprisonment or an imprisonment beyond 10 years, then also such cases they are fit for an appeal before Supreme Court. Otherwise, if High Court certifies that this case involves important interpretation of law, then such matter will be available before Supreme Court as an appeal. That is appellate jurisdiction in case of criminal matters. That we have to keep in our mind. So appellate jurisdiction in constitutional matters, appellate jurisdiction in civil matters. जहाँ पे हम ऐसा डिस्कस कर रहे थे कि हाई कोर्ट सर्टिफाई कर रहा है कि ये पर्टिकुलर केस में इम्पॉर्टेंट इंटरप्रिटेशन ऑफ लॉ है या किसी कॉन्स्टिट्यूशन के प्रोविज़न को इंटरप्रेट करने की ज़रूरत है. सिंस सुप्रीम कोर्ट इज़ द फाइनल इंटरप्रेटर, सो दीज मैटर्स विल बी अवेलेबल एज एन अपील बिफोर सुप्रीम कोर्ट. क्रिमिनल मैटर्स में मैं बोल रहा हूँ कि अगर देयर इज़ अ कंप्लीट रिवर्सल ऑफ जस्टिस, सबॉर्डिनेट कोर्ट ने एक्विट कर दिया है, हाई कोर्ट ने न केवल कन्विक्ट किया है बट आपको एक सिग्निफिकेंट पनिशमेंट भी दिया है, देन सच एन अपील इज़ अवेलेबल बिफोर सुप्रीम कोर्ट. ये थर्ड जो है आपको ऑप्शन दिया है कि हाई कोर्ट ने सर्टिफाई किया कि दिस केस इन्वॉल्व्स इम्पॉर्टेंट इंटरप्रिटेशन ऑफ लॉ और सर्टेन प्रोविजंस ऑफ इंडियन कॉन्स्टिट्यूशन, देन पिटिशन इज अवेलेबल बिफोर सुप्रीम कोर्ट एज एन अपील. बिसाइड्स दीज ऑल्सो, if your case, your matter is not fulfilling these criteria and if you are not satisfied with the judgment or order of high court, बट जो मैंने पिछले 3 आर्टिकल्स में आपको बताया कि ये कुछ क्राइटेरियाज हैं फुलफिल होने चाहिए, तभी आप अपेलेट जुरिडिक्शन एंजॉय कर सकते हैं. बट अगर वो क्राइटेरियाज फुलफिल नहीं हो रहे हैं एंड पिटिशनर इज नॉट सेटिस्फाइड विद द जजमेंट और ऑर्डर ऑफ हाई कोर्ट, सो यू हैव अ फेयर चांस टू गेट अ फेयर जस्टिस एंड यू विल मूव फॉरवर्ड स्पेशल लीव पिटिशन अंडर आर्टिकल 136. हियर स्पेशल लीव पिटिशन को एक्सेप्ट करना या रिजेक्ट कर देना, दैट इज डिस्क्रिशनरी पावर ऑफ सुप्रीम कोर्ट. तो यू कैन नॉट क्लेम इट एज अ मैटर ऑफ राइट, यू कैन नॉट क्लेम इट एज अ मैटर ऑफ सुप्रीम कोर्ट. दे में admit, they may refuse also in such special leave petition, but such special leave petition will not extend on matters which has been decided by Armed Forces Act or those courts which have been established under Armed Forces Act. So Armed Forces के matters को deal करने के लिए special courts होती हैं और उनके द्वारा डिसाइड गया कि इस मैटर में आप स्पेशल लीव पिटिशन नहीं लगा सकते हैं. और अभी जस्ट थोड़ी देर पहले मैंने आर्टिकल 262 को एग्जाम किया था अंडर original jurisdiction में, but here you may move a special leave petition with respect to any water dispute tribunal judgments. So such matters they may be moved to Supreme Court under this route, that is special leave petition route, that you have to keep in your mind. So the next thing that I am going to discuss with you people, that is advisory jurisdiction. Friends, advisory jurisdiction मैंने आपके साथ पहले भी डिस्कस किया व्हेन आई वाज डिस्कसिंग पावर ऑफ इंडियन प्रेसिडेंट, जहाँ पे मैंने आपके साथ डिस्कस किया था कि प्रेसिडेंट ऑफ इंडिया में सीक एडवाइस ऑफ सुप्रीम कोर्ट ऑफ इंडिया ऑन सर्टेन इश्यूज विच आर issues dealing with important aspect of law or the issues which are of public importance. President they may seek advice of Supreme Courts on such matters. President of India he may seek advice of Supreme Court in case of any dispute which are arising of the pre-constitutional treaty, agreement, sanad or convention. There also President may seek the advice of Supreme Court. इन फर्स्ट केस जहाँ पे मैंने आपको बोला कि प्रेसिडेंट सुप्रीम कोर्ट की एडवाइस ले रहे हैं ऑन एनी मैटर विच इन्वॉल्व इम्पॉर्टेंट इंटरप्रिटेशन ऑफ लॉ और एनी मैटर विच इज़ ऑफ पब्लिक इम्पोर्टेंस, वहाँ पे सुप्रीम कोर्ट एडवाइस दे भी सकते हैं और एडवाइस नहीं भी दे सकते हैं. इट इज़ नॉट बाइंडिंग ऑन द पार्ट ऑफ सुप्रीम कोर्ट टू गिव एडवाइस इन फर्स्ट टाइप ऑफ मैटर वेर इट इन्वॉल्व्स इम्पॉर्टेंट क्वेश्चन ऑफ लॉ और इट इज़ ऑफ इम्पॉर्टेंट पब्लिक importance. But second case में where you are seeking advice on any pre-constitutional treaty, agreement, sanad or convention, here Supreme Court is bound to give advice. This thing you have to keep in your mind कि पहले तरह के matters में first type of the cases there is no such obligation on the Supreme Court to extend advice, but in second kind of the matters there is obligation on the part of Supreme Court to extend such advice, but any such advice in both type of cases tendered by Supreme Court is not binding on President. President may ignore such advices which has been tendered by Supreme Court. That you have to keep in your mind. So whenever such matters are referred by President to Supreme Court, Supreme Court constitute a constitutional bench. Now you will be thinking कि what exactly is constitutional bench. तो हमने आपके साथ पहले भी डिस्कस किया when bench strength is of 5 judges or more than 5 judges, such benches are known as constitutional bench. So the last presidential reference was made to Supreme Court on 2G spectrum allocation case, जिसमें सुप्रीम कोर्ट से ही प्रेसिडेंट पूछ रहे थे कि पब्लिक पॉलिसी के डिसीजन में क्या जुडिशरी को इंटरफेयर करना चाहिए या नहीं करना चाहिए. सो सच रेफरेंस वाज मेड बाय प्रेसिडेंट ऑफ इंडिया बिफोर सुप्रीम कोर्ट कि ऑन पब्लिक पॉलिसी डिसीजंस विच आर द प्रोरोगेटिव ऑफ एग्जीक्यूटिव. एग्जीक्यूटिव ने अगर कोई डिसीजन लिया है तो क्या उसमें सुप्रीम कोर्ट दे आर well placed to interfere or not. That was a presidential reference made by President of India before Supreme Court. And this last aspect that I am referring with regard to jurisdiction of Supreme Court, that is a judicial review. A judicial review as a phrase, as a word is nowhere mentioned in Indian Constitution. That we have already discussed कि indirectly it derives its legitimacy from Article 13 of Indian Constitution. Implicitly it derives its legitimacy from Article 13 of Constitution. This word judicial review explicitly it is nowhere mentioned in Indian Constitution. So देखिए जो traditional separation of power हमने discuss किया है, that traditional separation of power is which was proposed by Montesquieu, that is there should be clear separation of power among legislature, executive and judiciary. But the kind of parliamentary form of government we adopted from Great Britain, here there is an overlapping between legislature and executive, but judiciary is outside that overlapping, and because of that any act, policies which has been formulated or enacted by legislature or executive, that is available before judiciary, judiciary can review it. Judiciary can see that whether they are violative of any constitutional provisions or not, and if yes, then judiciary may declare it unconstitutional and void. As such power it has been conferred to only High Court and Supreme Court. So जब मैं आपके साथ आर्टिकल 13 डिस्कस कर रहा था, ये जुडिशियल रिव्यू पावर मैंने डिटेल में आपके साथ डिस्कस की है. यहाँ पे बस मैं आपको रिफर कर रहा हूँ कि जुडिशरी हैज़ पावर टू रिव्यू the enactment made by legislature and policies formulated by executive, that whether they are violative of any constitutional provision or not, and if yes, then judiciary may declare it unconstitutional and void, illegal. That is the power of what? Judicial review. That we have already discussed, and again here we are discussing ये जो जुडिशियल रिव्यू की पावर है कॉन्स्टिट्यूशन में कहीं भी डायरेक्टली मेंशन नहीं है. आर्टिकल 13 में इसका इम्प्लिसिट मेंशन हमने आपके साथ डिस्कस किया था वाइल डिस्कसिंग चैप्टर ऑफ फंडामेंटल राइट, एंड ओनली हाई कोर्ट एंड सुप्रीम कोर्ट दे एंजॉय this power of judicial review. That thing you have to keep in your mind. Then there are certain provisions that I have mentioned here, even though that is not part of the jurisdiction of Supreme Court, but कई बार prelims examination में multiple choice question में पूछा गया है कि out of these provisions, which are the provisions which are there in our constitution just to ensure independence of what? Judiciary. So there are such 7-8 provisions which are mentioned in our constitution that try to make Indian judiciary, which is the final interpreter of constitution, impartial, neutral and unbiased. So their mode of appointment of judges, जिसमें हमने ऐसा डिस्कस किया कि मिनिमम और नो रोल है लेजिस्लेचर और एग्जीक्यूटिव का. सो दे आर इवन दो अपॉइंटेड बाय प्रेसिडेंट बट दे आर नॉट सरकारी जजेस. दैट वी हैव टू अंडरस्टैंड कि दे आर people who are part of government, but they are then they are not part of government. They are there just to make sure that rule of law shall prevail in country. So mode of appointment of judges, their salaries, allowances and other expenditures which are charged on consolidated fund of India, they have been given lots of freedom to appoint their own judicial staff. देन सिक्योरिटी ऑफ टेन्योर हमने आपके साथ डिस्कस किया, वेयर अपर एज लिमिट हमने डिस्कस किया, किस तरह डिफिकल्ट है उन्हें हटाना, दैट वी हैव डिस्कस. देन कंडक्ट ऑफ जजेस कैन नॉट बी डिस्कस अनलेस अंटिल इम्पीचमेंट मोशन इज बीन गोइंग ऑन अगेंस्ट एनी पर्टिकुलर जज. Then ban on practice after retirement on Supreme Court judges. Then their power to punish for their contempt if people try to scandalize or lower the image or dignity of judiciary. Then their jurisdiction cannot be curtailed. इसे बढ़ाया जा सकता है बट इसे कम नहीं किया जा सकता. तो देखिए ये सारे कुछ important provisions हैं that are there to maintain independence of higher judiciary, particularly Supreme Court and High Court. Then seat of Supreme Court is also mentioned under Article 30, which says Supreme Court of India will sit at Delhi. So these are the various provisions which are there just to maintain independence of what? Higher judiciary, particularly Supreme Court and High Court. So friends, through this particular session, I try to give you one fair idea when a better understanding on jurisdiction of Supreme Court, appointment and removal of judges, that we have already discussed in the previous session. अगर आप में से किसी ने मिस किया है, so they should go through our playlist and they should see that thing. In next class again I will come up with some important aspect dealing with our Indian polity and constitution. Till that time you should revise these things. If you have any doubt, any confusion, please write to me. I will try to solve those doubts, those confusions, and I hope that through these sessions, through these lectures, definitely you people might be having